Welcome back to SCOTUS Oral Arguments and Opinions. Today, the Supreme Court handed down 5 decisions. We'll discuss each of them. In this episode, we'll unpack the June 18th, 2025 Supreme Court opinion in the case called NRC v. Texas, case number 23-1300. This case was consolidated with Interim Storage Partners, LLC V, Texas, case number 23-1312. We'll first walk through the majority and the dissent, and then discuss a couple of case implications. Please note that this summary is read by an automated voice. The basic facts are straightforward. A private company called Interim Storage Partners wanted to build a facility in West Texas to store spent nuclear fuel from power plants around the country. Texas and a local landowner named Fasken objected, arguing federal law doesn't allow such private storage facilities. But here's the wrinkle. The threshold question wasn't whether the company had legal authority, but whether Texas and Fasken even had the right to challenge the decision in court. The Supreme Court ruled that Texas and Fasken couldn't bring their case in federal court because they weren't considered parties aggrieved under the Hobbs Act, primarily due to their failure to formally intervene in the NRC's administrative hearing. This decision underscores a critical point. Active participation in agency proceedings is essential to secure your right to judicial review. Justice Kavanaugh delivered the opinion of the court, in which Chief Justice Roberts and Justices Sotomayor, Kagan, Barrett, and Jackson joined. Justice Gorsuch filed a dissenting opinion, in which Justices Thomas and Alito joined.
Justice Kavanaugh's majority opinion, the Atomic Energy Act of 1954 generally prohibits the private possession of nuclear materials, including spent nuclear fuel, without a license. The Nuclear Regulatory Commission may license the possession of nuclear materials subject to statutory and procedural requirements. Here, Interim Storage Partners, ISP, applied for a license to build a facility in West Texas to store spent nuclear fuel. During ISP's licensing proceeding, a Texas government agency submitted comments, including comments on a draft environmental impact statement, EIS, prepared by the Commission for the proposed facility. Fasken Land and Minerals, a private West Texas business, similarly submitted comments, and it also sought to intervene in the licensing proceeding. The Commission denied Fasken's petition to intervene. Fasken then unsuccessfully challenged that denial of intervention before the full Commission and the D.C. Circuit. In September 2021, the Commission granted ISP a license to build and operate its proposed storage facility. Texas and Fasken sought review of the Commission's licensing decision in the Fifth Circuit. The Fifth Circuit vacated ISP's license, held because Texas and Fasken were not parties to the Commission's licensing proceeding. They are not entitled to obtain judicial review of the Commission's licensing decision. A. In the Hobbs Act, Congress specified that only a party aggrieved by a licensing order of the Commission may seek judicial review. Texas and Fasken argue they qualify as parties because they participated in the licensing proceeding by submitting comments on the draft EIS and, in Fasken's case, by attempting to intervene. But the text of the Atomic Energy Act indicates that one must be the license applicant or successfully intervene in order to obtain party status in a Commission licensing proceeding. The Act provides, the Commission shall grant a hearing upon the request of any person whose interest may be affected by the proceeding, and shall admit any such person as a party to such proceeding. That text means that a person becomes a party only after that person requests to participate in a hearing before the Commission, that is, requests to intervene, and is actually admitted to such proceeding by the Commission. And if the Commission fails to admit someone as a party, that person is not a party. B. Fasken contends that it can maintain this suit because it satisfied the statutory criteria for intervention under the Atomic Energy Act, and the Commission erroneously denied its intervention petition. Fasken also argues that the Commission's intervention regulations set a higher bar for intervention than the Atomic Energy Act contemplates. But Fasken could, and already did, obtain judicial review in the D.C. Circuit of the denial of its petition to intervene. In the D.C. Circuit, Fasken did not question the legality of the Commission's intervention regulations. Fasken simply challenged how the Commission applied its regulations in this case. But the D.C. Circuit rejected Fasken's arguments and upheld the Commission's denial of Fasken's petition to intervene. And Fasken did not seek en banc review in the D.C. Circuit or certiorari in this court. The decision on intervention is final. Fasken cannot now use a new Hobbs Act suit to collaterally attack the D.C. Circuit's prior ruling on intervention. C. Texas and Fasken alternatively argue that they need not be parties to challenge ultra vires agency action. Because ultra vires review could easily circumvent judicial review statutes, this court's cases have strictly limited non-statutory ultra vires review. The court's leading case on ultra vires review is Leadham v. Kine, 358 U.S. 184, holding that non-statutory review was available because the agency order was an attempted exercise of power that had been specifically withheld and violated a specific prohibition in the National Labor Relations Act. The Kine exception is a narrow one that does not apply simply because an agency arguably reached a conclusion which does not comport with the law. Boyer, 376 U.S. at 481. Rather, it applies only when an agency acts entirely in excess of its delegated powers and contrary to a specific prohibition in a statute. For at least two reasons, Texas's and Fasken's ultra vires claims fall short. First, Texas and Fasken basically dress up a typical statutory authority argument as an ultra vires claim. Second, ultra vires review is unavailable, where a statutory review scheme provides aggrieved persons with an adequate opportunity for judicial review. Here, entities like Texas and Fasken seeking intervention are guaranteed judicial review of either the Commission's intervention denial or, if intervention is granted, the Commission's final licensing order. Additionally, no precedent supports bringing an ultra vires claim in a court of appeals rather than first in a district court. D. Because Texas and Fasken have no right to judicial review of the licensing proceeding, the court today does not decide whether the Commission possessed statutory authority to issue a license to ISP 16-21. Reversed and remanded.
Justice Gorsuch's dissenting opinion. By law, spent nuclear fuel may be stored on an interim basis in only two places, at a nuclear reactor or a federally owned facility. Disregarding those instructions, the Nuclear Regulatory Commission NRC issued an interim storage license to a private company, Interim Storage Partners, LLC ISP, allowing it to store thousands of tons of spent nuclear fuel on its private property in Texas, hundreds of miles from the nearest reactor. The agency's decision was unlawful. Still, the court says, there is nothing we can do about it. Why? Because neither of the respondents before us is a party aggrieved by the agency's decision. Yes, the respondents are the state of Texas and Fasken Land and Minerals Limited, a landowner with property near the proposed facility. And yes, they are aggrieved by the NRC's decision. Radioactive waste poses risks to the state, its citizens, its lands, air, and waters, and it poses dangers as well to a neighbor and its employees. But the court insists the agency never admitted Texas or Fasken as parties in a hearing it held before issuing ISP's license, and that's the rub. Maybe the agency's internal rules governing who can participate in its hearing are highly restrictive. Maybe those rules are themselves unlawful. But the court reasons its hands are tied. The agency did not admit Texas or Fasken as parties in its hearing, and that is that. I cannot agree. Both Texas and Fasken participated actively in other aspects of the NRC's licensing proceeding. No more is required for them to qualify as parties aggrieved by the NRC's licensing decision. Both are entitled to their day in court, and both are entitled to prevail. Turning first to the question whether the NRC may license a private company to store spent nuclear fuel, not at a reactor or on federal land, but on its own private property. This interim license runs for 40 years, subject to renewal. Can the agency lawfully issue such a license? The answer is not hard to come by. The NWPA authorizes only 2 places where spent nuclear fuel may be stored on an interim basis, at reactor sites or on federal property. When it comes to that direction, Congress was clear, as it could be, adding that nothing in the NWPA shall be construed to encourage or authorize storage at any facility located away from the site of any civilian nuclear power reactor and not owned by the federal government. Given Congress's emphatic instructions, how did the NRC come to the view that it possesses authority to do what the NWPA forbids? It's a convoluted story. Before the NWPA's adoption in 1982, the agency observes, the AEA represented Congress's primary legislation in the field of civilian nuclear power, and the agency says it issued regulations pursuant to that statute in 1980, contemplating licenses like ISPs. Congress, the agency continues, must have been aware of those regulations when it adopted the NWPA in 1982. So, the agency reasons Congress cannot have meant for its new legislation to disturb them. As a result, the NRC says it was entitled to rely on those regulations to issue ISP's license. That argument is unpersuasive. Agencies are creatures of statute, and they have no authority to dispense licenses except as Congress provides, and nothing in the AEA authorizes the NRC to license the storage of spent nuclear fuel at private off-site facilities like ISPs. Just recall, at the time of the AEA's enactment in 1954, most assumed that spent nuclear fuel would be reprocessed and reused, not stored for millennia. Reflecting that assumption, the AEA did not even mention spent nuclear fuel, let alone address its storage. Congress first provided for the storage of spent nuclear fuel only in 1982, with the adoption of the NWPA. And that statute forbids, not authorizes, licenses like ISPs. In the past, the NRC itself has acknowledged as much. In 1978, the agency's chairman recognized that the AEA did not explicitly authorize the regulation of radioactive waste facilities. And in the same 1980 regulations, the NRC now seeks to rely upon to issue a license to ISP. The agency conceded that the need for a place to store spent fuel for a number of years became apparent only following the president's deferral of reprocessing of spent fuel in April 1977. To be sure, the NRC now has a theory why the AEA authorizes it to issue regulations regarding the storage of spent nuclear fuel and grant licenses like ISPs. The agency points to 3 provisions of the AEA that allow it to issue licenses to entities seeking to possess special nuclear material, distribute source material, or use byproduct material. And the agency submits, if you cobble together special, source, and byproduct material, you wind up with spent nuclear fuel. So while the AEA may not contain a single provision addressing the storage of spent nuclear fuel, the agency insists, taken collectively, these 3 provisions effectively authorize it to issue regulations and licenses regarding the storage of spent nuclear fuel. The agency's theory may get marks for creativity, but it fails for at least 3 independent reasons. First, it's hard to see how the power to license the use of special, source, and byproduct material amounts to a power to license the storage of spent nuclear fuel. In briefing before us, even the agency admits that spent fuel is a substance different from any one of its constituent parts, and Congress itself has defined those terms very differently. Under the NWPA, spent nuclear fuel must have been withdrawn from a nuclear reactor following irradiation and must not have undergone reprocessing. Meanwhile, the AEA's detailed definitions of special, source, and byproduct materials include neither of these requirements. Elsewhere, too, Congress has distinguished spent nuclear fuel from special, source, and byproduct materials. While the AEA, as enacted in 1954, said nothing about spent nuclear fuel, in 1988, Congress amended that law to incorporate the NWPA's definition of the term. So today, the AEA authorizes the NRC to ensure that certain byproduct materials, source materials, special nuclear materials, and spent nuclear fuel transferred in the United States are done so in a specific manner. If the agency were right, and spent nuclear fuel really is just the sum of special, source, and byproduct materials, Congress's inclusion of the phrase spent nuclear fuel would have been meaningless. And we do not usually presume that Congress takes the trouble to amend its laws to add words and phrases that perform no work. If more evidence were needed, the 1980 regulations on which the NRC now seeks to rely would provide it. There, the agency explained its view that spent fuel includes the special nuclear material, byproduct material, source material, and other radioactive materials associated with fuel assemblies. Even in the 1980 regulations the agency invokes to justify ISP's license, then the agency itself admitted that spent nuclear fuel includes materials besides special, source, and byproduct materials. The agency cannot have it both ways. Second, the AEA authorizes the NRC to license the use of special, source, and byproduct materials only for very specific purposes, and storage is not among them. So, for example, the AEA says that the agency may grant licenses for the possession of special nuclear material for activities like research and development, medical therapy, and industrial or commercial purposes. The provisions speaking to source material and byproduct material contain similar lists of approved uses. None of those lists discusses storage as an approved use. The agency admits that the AEA does not expressly authorize it to issue licenses for storage. But, it replies, the statute does so implicitly. For support, the agency points to the fact that the provisions discussing special, source, and byproduct material each contain a catch-all. So, for example, Section 2073A authorizes the agency to license the possession of special nuclear material, not just for medical research and the like, but also for such other uses as the Commission determines to be appropriate to carry out the purposes of this chapter. And, the agency says, it has determined it appropriate to issue licenses for the interim storage of spent fuel to private companies like ISP. That hardly works. As this court has repeatedly recognized, a catch-all at the end of a list of specific items is typically controlled and defined by reference to the specific classes that precede it. So, the catch-alls before us cannot be read as permission to the NRC to go forth and do good. Instead, they must be read in light of and consistently with the lists that precede them. And here, all of the activities listed in Section 2073, Section 2093, and Section 2111 involve the affirmative productive use of the materials in question, not their passive storage. Third, even assuming, against all the evidence, that the AEA once might have implicitly authorized the NRC to grant licenses like the one at issue here, it cannot be fairly read to do so after Congress adopted the NWPA in 1982. If the AEA spoke at all to the storage of spent nuclear fuel, it did so elliptically and without offering any specifics about what sort of storage might be appropriate. The NWPA, by contrast, speaks directly to spent nuclear fuel and the question of its storage. In doing so, that law makes plain that only two kinds of interim storage sites are permissible, and knowing that much is enough to know that the NWPA must govern for it is a familiar rule of statutory construction that a specific statute controls over a general one. Really, any other conclusion would make a mockery of Congress's work in the NWPA and risk rendering it a dead letter. What was the point of legislation specifying 2 and only 2 appropriate sites for the interim storage of spent fuel if the NRC possesses the power to authorize interim storage wherever it thinks best? And what was the point of Congress later amending the NWPA to authorize 1 and only 1 permanent storage site if nothing prevents the NRC from issuing 40-year interim licenses and renewing them indefinitely? If there are answers to those questions, the agency has not supplied them, despite insisting that we lack jurisdiction to reach the merits of Texas's and Fasken's claim. The court proceeds to devote a healthy section of its opinion to the merits anyway. That is surely a curious choice, for anything the court might say about the merits of a case over which it lacks jurisdiction is pure dicta. Maybe worse, the court's dicta is simply wrong. The court argues that the NRC's decision to issue a license to ISP is justified by history and precedent. Yet neither the court's revisionist history nor its irrelevant precedent can imbue the NRC with novel authority that appears nowhere in any statute. Take precedent first. According to the court, we and others have interpreted the Atomic Energy Act of 1954 to authorize licenses for the storage of spent nuclear fuel. In truth, this court has never decided that question. Our decision in Pacific Gas simply acknowledged that the NRC in 1980 promulgated detailed regulations governing storage and disposal away from the reactor, an undisputed fact about regulations no one had challenged, along the way to holding that neither the AEA nor those regulations preempted a California statute pausing in-state construction of new nuclear plants until more spent fuel storage became available. As for the lower courts, the best the court can muster is a D.C. Circuit case that had no occasion to resolve whether the AEA authorizes the NRC to license private, off-site storage, for the parties there conceded that the NRC had just such authority under the 1954 statute. History doesn't get the court any further. As the court sees it, the NRC must have the power to issue licenses to facilities like ISPs because it has done so in the past. But no agency can exercise power without lawful authority, and repeating a wrong does not make it right. Notice, too, what the court has to say about the agency's past practices. There are about 10 privately owned storage sites where there are no active nuclear reactors. That careful phrasing obscures that none of those facilities is anything like ISPs. 8 facilities, seemingly included in the court's count, are not off-site storage sites at all, but privately owned nuclear reactor sites that have ceased reactor operations. Meanwhile, the G.E. Morris facility was initially built to serve as a reprocessing facility and only became a storage facility by default after reprocessing collapsed. That leaves just one example where it appears the NRC has invoked its 1980 regulations to license a private, off-site storage facility, and that facility was never built. I struggle to see in any of this the significant support the court claims for what the agency did here. One other aspect of the court's merits analysis warrants mention. In the court's view, if the AEA did not authorize the NRC to issue a license to ISP, that would mean private individuals and companies could store spent nuclear fuel anywhere and do so without a license. That conclusion does not follow for at least 2 reasons. First, as we have seen, in 1982, the NWPA addressed spent nuclear fuel directly, and that statute authorizes its storage in only 2 locations. Second, even before the NWPA, when most thought spent nuclear fuel would be reprocessed, the AEA was not blind to the fact that nuclear reactors would generate spent fuel, nor did the AEA tolerate its storage by anyone anywhere. To the contrary, the AEA authorized the NRC to license reactor facilities only so long as they could be operated safely. Before issuing a license consistent with that mandate, the NRC understood it had to determine that a reactor facility could safely store spent fuel on an interim basis. Indeed, we are told that, for safety reasons, spent fuel usually must be stored on site for at least 5 years. It follows then that under the AEA, the operator of a licensed reactor would have been authorized, and in fact required, to keep spent fuel on site after removing it from a reactor. It does not follow that the AEA permitted other parties without a license to take spent nuclear fuel off-site and do with it what they pleased. Without any persuasive argument on the merits, the NRC urges the court to dismiss Texas's and Fasken's claims on jurisdictional grounds. Ultimately, the court does just that, and thus paves the way for the agency to issue its misbegotten license. As the court sees it, Texas and Fasken cannot challenge the NRC's decision in court because they failed to jump through the right hoops before the agency. The court's reasoning follows this path. Texas and Fasken seek judicial review under the Hobbs Act. That statute permits any party aggrieved by an agency's final order to file a petition to review the order in the Court of Appeals wherein venue lies. And in the court's estimation, neither Texas nor Fasken qualifies as a party aggrieved by the NRC's decision. In reaching that conclusion, the court does not and cannot question that Texas and Fasken have much at stake. ISP's plan to store radioactive waste in the Permian Basin threatens harm to their citizens and employees, poses risks to their lands, air, and waters, and will diminish the value of Fasken's property. Lower courts have often assumed the phrase party aggrieved in the Hobbs Act requires those seeking relief from an agency's final order in court to have been parties to any proceedings before the agency, preliminary to issuance of the challenged order. The court proceeds on that same assumption today. For present purposes, let us take it as given. Doing so raises a few questions. First, what was the final order in this action? Plainly, the NRC's licensing decision. Second, what were the proceedings before the agency preliminary to issuance of that order? As we have seen, the NRC's licensing proceeding comprised several parts, including the safety review, environmental review, and a Section 2239 hearing. Third, who qualified as a party in that proceeding? To answer that question, the court relies on a line of D.C. Circuit cases that recognize the degree of participation necessary to achieve party status varies according to the formality with which the proceeding was conducted. To my mind, that answer resolves this case. Focus on the agency's environmental review. Remember, that review was an essential component of its licensing proceeding. The NRC itself admits that it could not sign off on ISP's license without completing an environmental impact statement, weighing alternatives to ISP's proposal, including the possibility of denying it. Reflecting as much, the agency's final license package included a preamble in which the agency recorded various findings, including a finding that it had completed a final EIS. The package also included a concise public record of decision outlining the findings of the agency's final EIS, incorporating that document by reference and reporting its conclusion that ISP's license application should be granted. Texas and Fasken were parties to that component of the agency's licensing proceeding. After preparing a draft EIS, the agency solicited comments from the public. Both Texas and Fasken offered extensive comments, raising warnings about the impact of ISP's intended project on land, water, oil and gas reserves, and people. The agency accepted those comments and undertook to address them in its final EIS. That is enough to make Texas and Fasken parties to any proceedings before the agency preliminary to issuance of the challenged order. Simmons In administrative proceedings contemplating notice and comment, lower courts have long said that commenting qualifies an individual as a party for purposes of the Hobbs Act. That much is surely right, and it means that Texas and Fasken are parties who may be heard in court under the Hobbs Act. For its part, the court seems to consider Texas's and Fasken's participation in the agency's environmental review irrelevant. As I understand it, the court thinks that to qualify as a party, Texas and Fasken also had to successfully intervene in the agency's Section 2339 hearing. I fail to see why. By the terms of one statute and set of regulations, the agency may have had to offer a public hearing, but by the terms of other statutes and regulations, the agency also had to conduct, among other things, an environmental review and a safety review. Each of these steps, the agency insists, was necessary before it could reach a decision on ISP's license application. And all of the agency's various tracks of review culminated in a single decision. Indeed, the agency incorporated the conclusions of each into its final license package. And without doubt, Texas and Fasken participated as parties in the environmental review portion of the agency's licensing proceeding. The Hobbs Act requires no more. That conclusion is confirmed by the terms of Section 2239 itself. The statute provides that, in any proceeding, for the granting of any license, the NRC shall grant a hearing upon the request of any person whose interest may be affected by the proceeding, and shall admit any such person as a party to such proceeding. With this language, Congress clearly sought to ensure that anyone affected by the agency's decision would have at least one forum in which to express their views to the NRC. But nowhere did Congress say Section 2239 is the only way someone can participate in the agency's licensing proceeding. The Northwest Public Affairs prohibits the Nuclear Regulatory Commission from licensing the storage of spent nuclear fuel at privately owned sites like internet service providers. Despite that command, the NRC forged ahead anyway. As the Fifth Circuit recognized, the agency's decision was unlawful. Nor does anything in the Hobbs Act prevent us from admitting what we know to be true. Both Texas and Fasken are parties aggrieved by the agency's decision. The NRC's theory otherwise requires us to ignore the full scope of the agency's own licensing proceeding. It forces us to reimagine a statute expanding public access to the agency's administrative proceedings into one restricting access. And it asks us to believe that the very state in which the agency intends to store spent nuclear fuel indefinitely cannot be heard in court to complain about the agency's plans, because nothing in the law requires us to indulge any of those fantasies. I respectfully dissent.
Case implications. Those were the majority and dissenting opinions. Let's turn now to case implications. The Supreme Court's decision primarily clarifies and narrows the avenues for judicial review of Nuclear Regulatory Commission, NRC, licensing decisions under the Hobbs Act. By emphasizing that only a party to the agency proceeding, meaning a license applicant, or a successfully admitted intervener, can seek judicial review of the final licensing order, the ruling places a significant procedural hurdle before states, landowners, and other affected entities. This outcome underscores the importance for interested parties to meticulously navigate and satisfy agency intervention requirements if they wish to preserve their right to challenge a final licensing decision in federal court. While the court deliberately sidestepped the substantive question of the NRC's statutory authority to license private off-site spent nuclear fuel storage, its procedural holding implicitly allows such licenses to proceed unchallenged by entities that do not successfully gain party status. This might encourage agencies to maintain strict adherence to their intervention rules, recognizing that such rules act as gatekeepers for subsequent judicial oversight. The decision does not, however, foreclose all future challenges to agency actions or authority, but it signals that the procedural pathway to the courthouse door for complex licensing matters under the Hobbs Act is a narrow one, requiring careful and timely engagement at the administrative level. Hope you enjoyed this episode. If so, please follow, share, and review. In the next episode, we'll cover EPA v's Calumet Shreveport Refining, LLC.